morning, Mr. Rankin. You might want to wait just a little bit. You may proceed.
Thank you, Madam Chief Justice, members of the Court. My name is Charles Rankin. With Randy Joyo, we represent the appellees who are here on the Court's grant of further appellate review. The case presents a very interesting issue of the authority of Boston College police officers to enter a dorm room and whether they were acting as special police officers with state action and hence governed by the Article 14 in the Fourth Amendment, or whether they were doing the bidding of their private employer. But frankly, the Court need not address that question because this is an issue that the Commonwealth did not raise below. And under settled case law, most recently in Betancourt 2 years ago, the Court said that if a party does not raise an issue below, it cannot complain on appeal.
Well, certainly the residency conditions were before the judge because she mentions them in her opinion. So if all the materials for the argument are there and she sort of addresses it a little bit, I guess I have some trouble with the idea that we've got it all in front of us and the Commonwealth loses. Let's just assume, and I'm not getting to the merits of your point, but the Commonwealth loses because even though it was all there, they didn't say some magic word in the motion to suppress?
Well,
and it's a matter of law?
It's not a matter of formalism, I don't think, Judge. I think it's a matter of what kind of record you're going to get.
Isn't it a matter of notice?
Isn't
it a matter of notice?
Well,
I mean, I don't know what, I haven't looked at the hearing. I don't know what the defense was at the hearing, but I assume that you want to know what you're up against.
Well, that's certainly part of it, and
Well, in what context were the conditions of residency introduced at the hearing?
they were introduced to show that the rules, conditions of residency prohibited the possession of any sort of weapon, including toy weapons or facsimile weapons. And that's what it was introduced. In fact, the prosecutor had the officer who introduced the conditions of residency read 2 paragraphs that relate to that question. There was no discussion of either of the issues that the Commonwealth raised for the first time in the appeals court, that is to say that the police officers were in fact private employees and thus there was no state action. If you read their memo, there's no reference to that in their memo in the Superior Court. And if the second issue is whether by signing the conditions of residency, acknowledging them, the students in fact consented to entry by the employees of the university, putting aside the question of whether the police were acting as employees or police officers.
Well, there are 2 kinds of consent, aren't there, that are raised by the residency rules? They essentially consent to entry for purposes of a plain view search. But as I read those rules, the question of consent to conduct a full search is an entirely different question. And that's really what we may have to decide in this case, is was there consent to conduct a full search?
In a way, this is like peeling an onion. And I think you're right that the residency conditions talk about a plain view search and the residents consenting to that.
And nothing here was found in plain view.
That's correct. The sequence was the officers enter the room without permission, order a third person who is...
Which they could do.
Under the
residency rules.
Well...
if no one was in the room, the police could have entered that room.
Well, I dispute that. If there was no one in the room, certainly the resident advisor, the dormitory staff could enter the room.
Well, but the conditions state that the university can come into the room. Who is going to act for the university? Would you expect that Father Monin is going to come in and act for the university?
This is precisely the reason why you have these matters litigated in the Superior Court, so that you have a record of who is responsible for enforcing these things. If you look at the record developed here, the officers were not acting as resident advisors doing a health and safety inspection. They were asking as a...
I'm suggesting who does the student expect is going to come in to perform a search?
Well, there's nothing in the residency conditions referring to the police.
Well, but it just says university.
Well,
The university can't act, it's a fiction. So it's got to act through its agents, and what agents would one expect would be performing a search, other than the
well,
police?
I think that the normal thing, given the context of the residency conditions, I think you would normally expect it to be resident advisors or maintenance staff,
But I
because
think-
that's the context of it.
It may be fair to conclude that university students would be surprised to discover that on a given Thursday morning, unbeknownst to them, a sergeant at his own direction would simply enter a particular student's room. Indeed, the resident advisor may be surprised to discover that. That, however, has not been established in the record one way or the other.
No,
And
well,
that's because it
well,
wasn't.
it was established that the resident advisor asked the police to come. That was
Correct.
established.
Well, what was established is they called the police, they went over and talked to them, and the first police officer testifies as to how it came to be that the police went there. And he testifies, we told the resident advisors that we, the police, were going to go there and take charge of this. You're going to go with us, but you're going to stand aside and not get in the way. So unlike Porter P., where you have a full record about the interchange between the shelter manager and the Boston police who were there and who was thinking about what, or in Nielsen, where you have two separate searches, or in the District of Columbia Court of Appeals decision that we cite, where the resident advisor does the search and the police are just there to hold the evidence, there's no record here because
Okay,
they
but,
didn't raise
all
it.
right, but fair point. But let's assume for the minute, just moving on to the merits, you do agree, though, that the language, the university, is different from either the language in Porter P. or the language in Nielsen, which really, I mean, both of them refer to the equivalent of the resident advisor.
It is different language, yes.
So that-
But I think that if the court, I mean, this is an area that is, I think, fraught with trouble for private employers, colleges and universities, lots and lots of people. As the amicus brief points out, there are a huge number of private security people. And so if we're going to permit police to be substituted for resident advisors, I suggested it has to be explicit, and that, as in Porter P., when you're talking about actual authority, apparent authority, and the court says that it has to be explicit that the police are entitled to come in and do the search, that should be the prevailing rule here.
But is there a difference with private employers and employees and this situation with the college, where the students sign off on a consent to search form?
Well,
Not on a form, but agree to.
they sign residency conditions, and, I mean, you've had residency conditions in Nielsen, you have residency conditions in the Porter P. case.
We're talking about the wide-ranging ramifications of this case and referring to private employers, and I don't see that it's the same situation.
Well, I think certainly if it had been the facts of this District of Columbia case, you would have no argument, or you might have had an argument, but not a successful argument from the defendants where the resident advisors are doing the search. Here you have the police doing the search, and from the very initial...
But who, when it says university will come in to search, who is it expected will come in? I mean, it's not expected that it's going to be the physics professor who's going to come in
Well,
and search the
I
room.
mean, you presume that it's going to be administrative personnel, and I don't see any reason to read this and think that it's going to be the police. There's, in fact, no mention of the police at all.
But would you say, does your argument depend completely on the fact that these are special police officers? That is, they are sworn? Right? In other words, if they were just Boston College employees,
I don't think we'd have any argument under Article 14 or the Fourth Amendment,
Okay.
because there would be no state action.
Okay. So the impact, so if you look at it, and you think of Leone and you think, well, there's some line here, not sure what it is. To take Justice Cowan's point, you've got a report, let's just say, of a gun, or a toy gun, or something, but a gun. I mean, maybe I saw the butt of a gun in the room. why would you not expect that when weapons are at issue and the residency conditions talk about safety and talks about how you can't have any weapons, why wouldn't you expect as a student that the Boston College Police might be involved in looking for that weapon?
Well, I guess it's a question of what kind of consent and the clarity of the consent that you want. And I also think that if Leone is the guiding star or the precedent that the court has to interpret and apply here, I think the facts here are so different than Leone that we fall on the side of the line where this is police action. I mean, if you look at just each step of the way, certainly you. If you have to draw a line, look at each step of the way.
You can start drawing lines, but you may draw one. We may disagree about entry, but then you've got the reaching under the bed, and then you've got the consent. I mean, yes, there are a whole series of steps.
Entering without uttering a word. You've got blocking the door. You've got uniformed officers with firearms holstered at their side. They say to one of the boys or the boys, do you have, we're here to investigate a report of a weapon. One of the boys said, I threw it away. The next thing that's given is Miranda warnings. That's not something that you'd expect to occur if it's merely private employees. So before you get to the meat of the search, you've got police activity. And at some point, we can differ about whether they have to be explicit in their residency conditions. But at some point, it transforms from being resident advisors who are concerned about this report of a student waving a knife and possibly having a toy gun to a police investigation.
Was there discussion in the court below regarding the conditions in regard to the authority of the police to come in?
You're talking about the trial court?
Yes, the trial court.
In the trial court, there was nothing about the authority, either consent from the residency conditions or the right to enter to do a plain view search. There was no testimony about it. That was not mentioned. As I said, the only mention, other than offering the exhibit, was to have the officer read 2 paragraphs that reflected that you couldn't have even toy weapons. So that's the record that was developed in the trial court. And in the post-argument memos, post-hearing memos, neither side addressed it. The Commonwealth didn't say, well, this is not a Fourth Amendment search because these are private employees. The Commonwealth didn't say, well, the boys consented to it. It was only in the appeals court that the Commonwealth raised it in their brief.
Well, they probably did say they consented the second stage or the third stage. You just mean consented by virtue of signing the residency.
I mean, there is a lot of complexity of the actual consent and whether the boys did consent. Judge Giles found that the Commonwealth had not met its burden to prove consent.
My only point is that consent was an issue, that one.
That was clearly an issue, but waiving the normal privacy rights was not an issue.
Mr. Rankin, can I ask you this? I'm just looking at the appeals court decision again. Did you raise the waiver issue in the appeals court?
Yes, Judge.
Have they addressed it?
They did not address it.
I didn't see it.
They didn't. I argued it
so
to them.
So there's no waiver of the waiver?
There's no waiver of the waiver. It was fully addressed, and I'll send a copy of our brief.
No, that's fine. I'll accept your representation, of course.
With regard to the second consent, the consent with the form, do you see that there was consent there and that it's just a question of the voluntariness of the consent, or do you not concede that?
We don't concede that there was consent.
You don't concede that, okay.
Because of the signing the Miranda part and not...
Well, the testimony of the police officers was all over the place. It was not consistent that either of the defendants verbally consented, and it's quite clear from looking at the forms that where the form is to be signed to give your consent to the search, there's no signature there.
Right.
There's a printed name there.
And what is your view as to whether Judge Giles found consent or did not find consent or did not reach it?
I think she found that the Commonwealth had not met its burden, and I think that's what she said. And she focused on several things. One is she said that any consent was vitiated by the illegal entry, and the court will decide if it was an illegal entry, obviously. Secondly, she said that the testimony was discrepant. That's the word she used, and she described the 3 different versions that came out in the testimony. And then thirdly, she referred to the failure of the police to get signatures on the consent to search forms.
She is, as I read her memorandum, findings and so on, the presumption from the get-go is these were police, state actors.
That's the way the case was litigated.
It's very difficult to go back and figure out what findings she did or didn't make if you say, no, these weren't police. These are janitors, resident advisors, somebody that they call themselves police, but they're not police. I mean, the whole thing is police.
I mean, it's a little odd that you have a private employer with an actual police department. I mean, you go to the Boston...
It's not odd, but there's a corollary that flows from that, namely, if you are police, you're police. It's very difficult to say, well, I'm only a police when I'm not a police, and here I'm not a police, even though I was doing exactly what the police would be doing, and the reason why I was called was because I'm a police officer.
I mean, just one final point, and I know my time is over. Here, you've got police officers coming into a dormitory room, which is like a home, as we know. And you've got police departments all over the Commonwealth that are associated with private employers, be they hospitals, colleges, universities, housing authorities, private security companies. If we permit a general consent form, like in this case, that does not mention consenting to police routine inspection of your dorm room, then the entirety of their privacy rights are going to be eviscerated.
No, go ahead.
I guess that was what I was going to say.
Could you help me with one fact point? I was confused in the briefs and in the judge's decision. Were any of these campus police officers also serving as, in a different shift, as police officers for your municipality?
There's no evidence of that in the record. The case was litigated as if they are Boston College police officers, as Chief Justice Marshall indicates there. This was police activity as far as the parties were.
They're just like
going.
Newton Police.
Yes, I mean it's unlike Nielsen, where or Leone, where the guy was a police officer in the municipality.
Thank you, Mr. Rankin.
Thank you, Your Honors.
May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney from Middlesex, appearing on behalf of the Commonwealth.
Good morning, Ms. Sylvia.
Good morning, Chief Justice. With me is Assistant District Attorney Melinda Thompson.
To address the issue of what happened in the trial court and the effect of introducing the conditions in evidence?
Yes, Your Honor. The Commonwealth's position is that the issue of the residency conditions is properly before this Court. The Commonwealth offered into evidence those residency conditions, and the judge ruled on those residency conditions in her decision.
Is there a reason that you didn't argue whether the students signed away any privacy rights they might have because of signing the conditions of residence?
Your Honor, I believe that the reason for that is because our position below was based on the premise that the police did not enter the room. That was the way that the case was litigated initially.
Police did not enter the room?
The testimony at the hearing, the testimony of at least 2 of the officers was that they stood at the doorway. They didn't step into the room.
But the sergeant did.
But one of them did.
One of them did, but based on the police reports that we received, and I would assume that the witness prep that Ms. Thompson did, that was the premise that we went forward on, that they did not enter the room, they stood at the doorway and spoke.
Well, surely you heard the testimony at the hearing that one of the officers said he went into the room.
Right, but having said that, we didn't know that the judge was going to rule the way that she did, which was, including the right of entry, saying, 2 officers testified that he did not step into the room. that all three of them stood at the doorway.
These are Boston College special police officers.
These
Or
are-
Boston College police officers with all the powers of special police officers.
Yes, Your Honor, they have powers of arrest and 20...
Wouldn't someone preparing to go into the hearing have thought that that the conditions of residency were important, and that the fact that the students signed them was relevant?
I think that the Commonwealth thought it was important enough to enter them into evidence.
Ms. Sylvia, let me ask you this. The waiver issue, just focus on the waiver issue for the moment, is whether the issue of whether they were state actors as opposed to, quote, private employees was raised in the trial court. So focus on that. There are lots of reasons why you want the conditions of residency in evidence, apart from anything else, because it provides for consent, right?
Yes, Your Honor.
But there's nothing that I can see that suggests that they are, that the conditions of residency, that the reason why the Commonwealth, in your words, was focusing on whether the police did or didn't enter was because everybody's assuming they're state actors. Because if they're not state actors, if they're just the janitor or the cleaning woman or the residency advisor, entry is not a problem. So would you agree with me, everybody is presuming that they are state actors?
Your Honor, I wouldn't say that I disagree with that. We didn't argue that at the appeals court either. And
Let me
frankly,
put
that's
it the other
reason
way.
why.
Nobody is signaling to the judge or to the defendant or to any of the witnesses. Nobody is even hinting there's an issue here about state action.
Right, and we didn't argue that on appeal at the appeals court. The appeals court reached out and decided the case based on the state action issue.
But
We didn't argue
we're bound by
that.
what happens at the trial court. So if nobody, as the Chief Justice has pointed out, if nobody is contesting the state action issue, why didn't you people go into the authority that the students may or may not have ceded to the college by means of the conditions of residency?
These are police officers. They are sworn police officers. They may be employees of the Boston College as opposed to the city of Newton, but they're police officers.
Your Honor, I agree with that. We didn't argue it on appeal for that reason, and I said that at the argument at the appeals court when they asked me
But
why.
Mr. Rankin tells me he's waiving, he's raising waiver. He's waiving waiver.
And what he raised as the waiver issue in the appeals court was the right of entry provision in the residency conditions. None of us thought of this in terms of a state action case. Your Honor is correct. That's not something that we raised. It's not something that the defense raised. And with regards to the waiver issue that the defense raised at the appeals court, it was with regards to the right of entry provision in the residency conditions, not with regards to the state action issue. That issue only came into play once the appeals court decided the case on that basis. And I would suggest that it's not necessary to decide the case
Are
on
you
that
saying
basis.
that the defendant argued in the appeals court the issue of waiver by the students of the right to enter, or giving permission to the university, to the college officials to enter?
He argued that we waived argument on the right of entry provision within the residency conditions that we entered into evidence and that the motion judge ruled on.
Ms. Sylvia, let me ask you this. You have the conditions of residency, at least the ones that I'm looking at, the right of entry and the weapons, firearms, and explosives conditions. If the resident director had called the Newton police as opposed to the Boston College police, would it have made a difference from your point of view?
Yes, Your Honor,
Why?
absolutely. Because of the fact that the right of entry provision provides for the university to enter the rooms. It doesn't provide for the Newton Police Department.
And that was argued before Judge Giles?
No, Your Honor, it was not. It was not argued as such.
So is it your view that a Boston police officer right now can enter into any dormitory room for the purpose of doing a plain view search?
No, Your Honor, the Boston Police Department does
No,
not.
Boston
It's not
College,
part.
Boston College
I'm
Police
sorry.
Department, I'm sorry. Is it that a Boston College police officer can right now walk into any room at BC and do a plain view search?
If there's reason to believe that the residency
No, no.
conditions.
No.
According to this, they reserve the right, there's no condition stated in this right of entry. It can be done for any reason as long as it falls within
I believe it says that
the upholding community standards, including safety and discipline.
Right, I believe they say they reserve the right to enter in order to.
So they could basically
accommodate
say,
the
we're going to be
standards."
searching for guns and drugs in every room, so they can just march into any room and do a plain view search.
Under the residency conditions, yes, I think that they can.
Okay, and according to you, if the if they get a university search warrant issued by the Vice President for Student Affairs, they could go into any room in BC and conduct a search of everything, including dressers and desks.
Yes, I mean, that's what the residency conditions provides for.
Do you think that we have to, was there any evidence to ask whether a reasonable interpretation of the term staff, where the policy so clearly differentiates between enter and plain view, you know, and I mean, we know that resident advisors enter, at lots of times they enter at 4 in the morning because they're not sure that somebody's returned. They enter because of noise. They enter for all kinds of reasons. And essentially, it seems to me that this policy is saying, you know, we can go in, somebody reports smoke, we can go in, so everybody knows we can go in. Do you think that the students understand that the police, qua police, can go in, give them Miranda rights at any time?
Your Honor, I think that it is reasonable to believe that students would understand these provisions to
I
mean...
understand you think it's reasonable to believe that. Is there any evidence that the university intended that?
Before the motion, Judge, no, there was not.
Because it wasn't an issue.
Right.
So there's nothing on which we have to go here.
Your Honor, I think that the motion judge, she did reach out and address the issue of the right of entry, and then she went in the wrong direction. And so I think that the Commonwealth is entitled on appeal.
But she's dealing with she's not dealing with them as staff. She's dealing with them as police officers, correct? I mean,
yes, Your Honor.
it's all the Fourth Amendment stuff is police officers.
Right, but just because it's police officer doesn't mean, as Porter P. points out, it doesn't mean that the residents can't consent to the police
No, of
entering
course
their
not.
room.
But the defendant is saying we give police an awful lot of authority, provided that they follow well-established procedures. And it looked as if these officers were trying to follow those police procedures. They trained police officers. They've been to the academy. It's not in the record, but I can practically stipulate
It is in
that
the
they've been to
record.
the police academy.
Yes.
So they've been trained. So they're acting as police officers. That's different than what a non-police staff can do. And it seemed to me that this policy is drawing that very clear distinction.
Your Honor, I don't, my reading of the policy is different. My reading of the policy is that the university reserves the right, they are part of the university, and that a reasonable student would expect, and not being so far away from college myself, I honestly believe this to be the case, that a reasonable student would expect that when you get a report of weapons and someone's going to come into your dorm room and conduct a plain view search for weapons, that it's going to be the police, not your history
Can
professor
I ask you
that
this?
does that.
I take it that the way that you would like us to write this decision would not mention the Fourth Amendment. It would not mention the Massachusetts Constitution. It would simply say, so all of your argument about Fourth Amendment and so on and so forth was not a seizure, demand, all of that is just irrelevant. The whole thing is irrelevant. And we just write a very simple opinion that says there was a contract, police officers, we may presume, are, quote, staff, as that term is used. They entered, and then there was consent.
Your Honor, that is exactly how the Commonwealth would like to see the decision.
Why
go.
didn't you argue that? Why have you got me all caught up in the Fourth Amendment and, you know, the Massachusetts Constitution? You've got lots of criminal cases here. I don't think you've got a civil case in the whole thing.
Well, Your Honor, I think that in light of...
They don't have to be reasonable.
I
The
think
resident advisor doesn't have to be reasonable, right?
I do think it has to be reasonable.
Why?
Because
Where
of
does
the
it have to be
fact-
reasonable? Resident advisor taps on the door, opens the door, wants to see in flagranto. I don't know what the resident advisor wants to do.
Because of the fact that under both Nielsen and Porter P., it talks about residents being able to consent to a reasonable search. I mean, if you're talking about an unreasonable search, I doubt very much that this court or another appellate court would uphold such a search.
But you're talking about entry.
Yes, Your Honor. We're talking about right of entry and, you know, which is a seizure in the constitutional sense if they haven't consented to that entry.
Let's talk about entry based on emergency. Is it part of your argument that report of weapons in a dorm room is presents a sufficient emergency to independently justify at least entering the room?
Your Honor, I think it certainly presents an emergency within the meaning of the word emergency in the residency conditions. And in support of that, I would point you towards the case of Boston Housing Authority v. Giarola, which is cited in the Porter P. case. It's also distinguished in a footnote from the circumstances in Porter P. And one of the ways that it's distinguished in that footnote is because of the fact that that search was justified by the fact that the presence of a lethal weapon in the housing projects presented an emergency within the meaning of the lease, and that the officers' actions were reasonable in those circumstances. And I also just want to point out that in this case, like in the Boston Housing Authority case, the resident director and the Boston College officers acted immediately, unlike in Porter P, where they waited a day to investigate the report of a gun. And I think that that adds dimension to our argument regarding emergency, because this is something that they investigated immediately. Even though it was past midnight on a school night, they immediately proceeded to the dormitory room of the defendants. And I think that that supports the argument that this was, in fact, something that the officers and the resident directors and the students that reported the presence of weapons in Gonzaga Hall believed this to be an emergency.
So thinking of these Boston College police officers strictly as police officers, would that be a sufficient basis for them to do what they did here, at least the initial entry? Or are you still saying it's because also of their special status as representing the university?
I think that I think it's both. I think it's the fact that they are special officers, they're employed by a private employer, that sort of, it adds a different dimension to our argument. I think that this, if you had the same contract at Fitchburg State College in the Nielsen case, I think that you would have the same result, or we should have the same result that we should in this case, which is that the Fitchburg State College police could have entered the dormitory. Having said that, the fact that Boston College is a private employer and the Boston College Police Department is more akin to perhaps a private security force than the Fitchburg State College Police Department, I think it does add a different dimension, and it makes it, it's a difficult question any way you look at it, but it makes it somewhat easier because of the fact that it's a private institution.
Were the students arrested?
I'm sorry?
Were the students arrested?
Yes, they were arrested at the end of the...
By who?
Arrested for drugs.
By whom?
They were arrested for drugs by the Boston
staff?
College Police.
By
Yes.
the college police. Was the evidence seized?
Yes, Your Honor.
By whom? By the staff?
By the Boston College Police, Your Honor.
So is it your view that the Boston College Police are always acting as staff, or that they can have two hats, a state police hat and a private security guard hat?
I mean, I think that that's a really interesting question. I think it's something that the appeals court struggled with at the oral argument as well. And I think that they can sort of wear two hats. I mean, because they certainly can investigate these sort of regulatory infractions that can occur underneath the residency conditions, but they also obviously have the power of arrest, and they have the power to investigate crimes and the power to get search warrants, which is actually something else I wanted to point out, that under the right of entry provision, it does provide, say that a search warrant may be obtained to conduct a full search. And I think that that sort of supports the Commonwealth's argument that a reasonable student would in fact expect the police department at Boston College to be the ones conducting a search for firearms rather than a librarian.
And what hat was this officer wearing when he gave Miranda warnings?
I think, Your Honor, that it may be fair to say at that point that he was no longer wearing the hat.
Wasn't he
of the
wearing, I mean,
staff.
I don't, you may not prevail on whether it was reasonable and so on, but I mean, he's a police officer. That's why he's being called, because he knows how to deal with weapons.
Mm-hmm.
He's not being called as a staff member, he's being called as a police officer.
Well, who else should be called to deal with when there's a suspicion that there's a gun in the room?
A police
And
officer.
I think that
And
that's...
believe me, if they didn't have their own police officers, they would have done it precisely what the woman did in a very thoughtful way in Porter P.
Right, and
Because people are not familiar with guns, they don't want to cause any harm. She would have called, whoever the resident man or woman would have called the Cambridge police. I mean, the Newton
I
police.
think what's really difficult about this case is that there arguably is not probable cause here. So you put a staff member in the position of either being the ones to go into a room and investigate the report of firearms, something they're ill-equipped to do. They're not licensed to carry firearms. They're not trained to carry firearms. And in fact, if they retrieved a weapon and carried it out of that room, they would be violating the law. I think you put them in the position of either doing that, putting themselves in danger, or doing nothing, because of
No,
the
you
fact that
take,
they're likely...
you get a police officer, which is precisely what you would do in any situation because it's a gun. The police officer may be a Boston College police officer, it may be a Newton police officer. You get a police officer, you go with the resident person who's there, you ask, for example, for consent to search. The resident person can ask for consent to search.
I think that that's exactly what they did here. They proceeded to the dormitory room along with the resident director. They knocked on the door. They opened the door. They stepped a foot into the door. And they conducted what amounted to a threshold inquiry, particularly under the residency conditions. And
They conducted a police threshold inquiry. The police were acting as police.
Your Honor, I do think that it's only reasonable to think that when you're talking about firearms, that when it says the university, that encompasses the Boston College Police Department.
Of course it does, but it's police. They're there acting as police. As Justice Cowan, I think, has asked several times, who else do you call? You call
Right.
the police.
Exactly, Your Honor, and that's permissible under the residency conditions at the university. It's permissible under the conditions that these students signed on to when they chose to live.
And one would, as you say, one would think the students would expect the police to show up if there were
Absolutely.
allegations of guns in a room.
Absolutely, that's
Boston
exactly
College
what
police.
that's exactly what they would expect to happen. And if there are no further questions from the panel, I would rest on my brief.
Thank you, Ms. Sylvia.
Thank you, Your Honor.